Members, again, welcome to Legislative University on Gaming. Courses over the next couple of days are opportunities for you to learn about the history of gaming, what the current status in Florida is, and other background and context that hopefully will prepare you as much as possible for next week. Today, this afternoon's course will focus on the current gaming landscape. Again, these are not committee hearings, and this is not the time to ask questions about the compact or debate what is or isn't in it. I hope that you will use these opportunities as a way to lay the foundation from which you can make an informed decision next week about a very complex and intricate topic. In addition to the House staff this afternoon, we'll be joined by staff from DBPR who will help discuss the current status in our state. We're going to lead off with Lou Trombetta from DPPR. When he's finished his presentation, you will be able to ask him questions. Then we'll turn to Kurt Hammond, who you heard from this morning, and you will also be able to ask him questions about his portion of the presentation. So please hold your questions until they get done with their presentations, and we will go from there. And Lou, I'll turn it over to you.
All right. Thank you, Leader Grant. Thank you for the introduction. My name is Louis Trombetta. I am the Director of the Division of Pari-mutuel Wagering within the Department of Business and Professional Regulation. Secretary Julie Brown is with me right here, so is my Deputy Director. The presentation that I've put together for you is intended to kind of give a general overview of how this industry works from the regulator's point of view. So it's going to cover a few subjects, what I've determined to be kind of a key concept to understand. We're going to touch on card rooms. We will touch on slots, but we're going to open with just kind of speaking about the division generally, kind of what we do, what we don't do, and then we'll move on from there. So if we could go to the next slide. So this slide offers some statistics and some basic information about the division. So the division is charged by statute with regulating the licensed pari-mutuel facilities in the state. So that means that if you walked into Magic City or Gulfstream or any of the licensed pari-mutuel facilities in the state, you would have a high chance of seeing somebody from our staff at that facility. We have 115 full-time employees located in different offices throughout the state. We have 3 full-time employees at every slot facility. We have employees stationed at some of the racetracks, and we have offices at almost every facility. With that group, we kind of split up the duties, but our big functions are really to secure tax revenue for the state, ensure the health and safety and welfare of the racing animals and the participants in the races, and to maintain the integrity of the wagering. So we have duties, I've kind of highlighted them in red from, we have an investigations team that goes around and collects evidence to forward to legal to open cases if we see violations. We have auditors that do things from compliance audits to purse audits to financial audits. We have a whole team dedicated to collecting and reconciling revenue data, and we do a whole number of other things. But the key thing to take away here is that we are responsible for the licensed activity. So we do not do anything involving like cruise ships or internet cafes. If somebody, often we get calls from people say, hey, this bar is running a poker game. Can you guys do something? That's not at a licensed pari-mutuel facility. So it's something that the division does not regulate and that we have very limited jurisdiction to do anything about. The next slide is going to jump right to some of these key concepts. So if we could go to the next slide, please. I apologize, I don't have control of the presentation at this point. So the big picture and the big takeaway here that I'd like to stress is the difference between permits and licenses. And even going bigger than that, so under the Florida Constitution, lotteries or gambling is prohibited unless it's a licensed pari-mutuel event. So if you think of it in the scheme of everything's prohibited unless it falls into an exception, permits and licenses are one of the largest exceptions to authorized gaming in the state. A permit is the first and most fundamental one to try to get a grasp of. So permits are created through voter referendum mostly, which is physically, people in the 30s, 50s, 70s, there were a lot of permits created through voter referendums. After the vote creates the permit is specific to a wagering type. In other words, you would get a thoroughbred permit, which would only allow you to conduct thoroughbred racing, or you could have a greyhound permit, but the permit is specific to the pari-mutuel activity. Permits are also specific to the location. So whatever location is specified in the initial permit application is where the permit will be physically located if it is issued. Permits can move, but it's a little bit complicated. So for the most part, just understand that permits are fixed to a location. Other big part is that permits, they do not expire. So once a permit is issued, it exists until it is taken away or somebody, voluntarily relinquishes it or gives it back to the state. So this leaves us in a situation where often the division gets asked questions about how many permits are there in the state, when what's really being asked is how many people are operating, because there are permits that are not operating. So that's one distinction that I think matters and that will be helpful for anybody kind of reading bills or just talking about this industry over the next week. Once you have a permit, you are eligible to apply for an operating license. So the operating license is good for a fiscal year. Permit holders apply for it between December and the end of January for the upcoming fiscal year. The operating licenses are specific to the permit and the permit type. So if you have a greyhound permit, you would annually apply for an operating license to conduct greyhound wagering, but you cannot do so until you have that license. So the operating license is what really authorizes the wagering. So the license is what gives the person the ability to accept wagers from people that they otherwise would not be able to do. A permit is the necessary initial step in getting the license. We cannot issue an operating license unless somebody has a permit. So the differences in these two concepts often leads to confusion that I think is best represented through an example of Magic City, which is in this table below. Magic City is a casino located in Miami-Dade County. If you walk into Magic City, you will see slot machines, there's a card room. Last time I was there was a greyhound track because they used to run greyhound races there when they could. And now there's a highlight fronton at Magic City. All of Magic City's initial licenses and permits are numbered. And the permits, the way the division operates is we operate based on permit numbers. So as I've listed in that table, permit 155 is the permit number associated with West Flagler's greyhound permit. Now this is the main permit that they've been operating under. If you look at all the way on the right, the associated licenses, under permit 155, there are 3 licenses associated with that permit. So again, this is often why there's a discrepancy between how many permits there are in the state and how many licenses there are in the state. So permit 155 has a greyhound operating license, a slot machine gaming license, and a card room license. So the greyhound operating license allows them until this year to accept wagers on greyhound racing. Now that greyhound racing has ended, the operating license is still used to allow them to accept wagers on other pari-mutuel events that they're being broadcast on monitors in the building. Because they have an operating license, they met the requirements, they were eligible to also receive a slot machine gaming license and a card room license. So the card room, if you physically walked into Magic City and you turned to the right and you saw the card room license is associated with permit number 155 and operating license 155. But those are not the only things that are happening in Magic City. If you walked in, you may see highlight being played. Permit 155 is a greyhound permit, not a highlight permit. So the highlight performances that you could physically watch at Magic City would be performed by a different permit holder that may or may not be associated with the Magic City location, and they would be operating with their operating license specific to that other highlight permit. So I've listed on this table 3 other permits that operate at Magic City. And I realize that it might add confusion by mentioning this, but the goal here is really to help you understand that the terminology matters because it leads to a lot of discrepancies if you're just focused on permits or if you're just focusing on licenses, or even if you're just focusing on facilities. So you really have to try to take a look at the big picture, because at a single casino in Miami-Dade, there are at least 4 permits operating or located at that facility. There's Greyhound permits and highlight permits located at the same building. There are multiple highlight permits all operating. That means they're conducting their physical races at the fronton at Magic City. So if you walked in, if you didn't have a schedule in hand, you may not know which highlight performance is actually being conducted, but just know that it's possible for different permit holders to conduct their performances at facilities which they don't necessarily own. So these all happen under a lease agreement, okay? And I'll accept questions on this in the future, as I imagine we may have some. But again, the big takeaway here is that you need a permit to get a license. There are different types of operating licenses that are all tied to a specific permit, and that focusing just on a facility may not capture the whole image, just like focusing on a permit may not capture the whole picture. You gotta look at everything. And if we go to the next slide, which if we could please, we've provided you with a map. So this map is a little bit modified from the version that we usually make available. I've tried to simplify it a little bit for purposes of this presentation. The colored bubbles each represent a different type of Greyhound permit. And this map is just showing permit holders with operating licenses. So there's another map later on you'll see that shows permit holders that did not have operating licenses. Because again, the permits they still exist even though somebody isn't operating. So you'll see there's a large number of Greyhound permits starting January 1 of this past year. The constitutional amendment prohibiting Greyhound wagering went into effect, so none of these Greyhound permit holders are actually conducting races. They receive operating licenses because the operating license is necessary for them to do intertrack wagering, which is allowing people to wager on events happening at other facilities. And it's usually a precondition to getting some other type of, whether it's a card room or a slot facility. The little circles labeled C represent card rooms. So just looking at that, you can see that there are a decent amount of card rooms in the state. You'll often hear the term coupling or decoupling. That concept is related to card rooms and slot machine gaming operating licenses. The concept is that in order to get a card room or a slot license, you would need to run some amount of live performances under the underlying permit. Now, Greyhound Racing, again, has modified this blanket rule. It used to be very easy to understand, but now the only caveat is that the Greyhound permit holders have essentially been decoupled. They no longer are allowed to conduct live wagering, or live events, I'm sorry, but the other gaming licenses, so the card room or slot licenses, cannot be affected by a performance requirement due to them not running. And then finally, the other thing that's showing on this map are the slot facilities. There are 8 slot facilities, 4 in Miami-Dade and 4 in Broward County. Slot gaming is also coupled to live racing or gaming performances. If we can go to the next slide, I'm going to start getting a little bit more specific. So now just addressing card rooms. So how does the state make money on card rooms? Essentially from 2 main ways, okay? The state, one, collects a 10% tax on gross receipts. A gross receipt is it's made from either taking what's called a rake from a card game or from a tournament entry. So think of your family sitting around the dinner table playing poker. The house would take $5 out of the middle of the pot every hand, and that's how the house makes money. The state gets 10% of that. The other main revenue source is from tournaments, and so this would be for poker tournaments. There's an entry fee associated with the poker tournament. The same tax rate, the same 10% is taken from the tournament entry fee. Overall, the state made about $14 million from card room tax revenue. This is for the 1920 completed fiscal year. The table below it explains exactly how someone gets a card room license. So these are, everything above the line shows the necessary requirements, right? You need a permit, you need an operating license. This is the pari-mutuel operating license. You have to complete an application. This essentially means you have to meet all the requirements that are in 550 or 849-086. And then for card rooms, there's a minimum number of performance requirements. The number of performances varies based on the permit holder. It's based on a historical looking back. So there isn't a set number. There is for each permit holder. So if you meet all these requirements, you're able to get a card room license. Things to be aware of with card rooms. First is that the division's rulemaking authority has been limited from previous cases at DOA. The most significant one was that the division at one time tried to define the term poker, and the DOA found that there was not rulemaking authority to do that, which made it a little bit difficult for the division to address some issues that came up. Moving to designated player games. So a designated player game is a game, and going back to the poker concept. So think of your family sitting around the circle dinner table, all playing poker, okay? You're all vying for the same pot. There's a single pot that all the players at the table are eligible to win depending on how good their hand is or if they bluff and make everybody else fold. A designated player game takes that, and instead of all the players playing against each other, all the players are playing against one person. So of the 6 people at the dinner table, all 5 of them are playing against dad. And, you know, mom has her own pot against dad, the son has his own pot against dad, daughter has her own pot against dad, and so on. And the winnings and losses are all sort of independent of themselves, except for the people against the designated player. The common element here is that the designated player is playing against all the other people at the table individually. That's the big difference between a designated player game and a poker game. But just some background, the division does not approve poker games. We ask for a list of games to be identified in application licenses, but the games do not have rules, and there is no formal approval process. So our role in regulating card rooms is to ensure that the games are authorized games as defined by statute, and we, to this day, conduct inspections to that end. Moving on to the next slide. This one covers slots. So the state makes money on slot machines, again, from a straight tax perspective. Slots are taxed at 35% of the net win. So the third row down shows the amount wagered. This is not the net win. This is the $6.5 billion is the amount wagered by patrons. Think of it like dollars in the machine, ignoring everything else. And this is also for one fiscal year at 8 slot facilities in Miami-Dade and Broward. This does not include any Seminole properties. So of the $6.5 billion wagered, the facilities will keep a big portion of it. Essentially, what's taxed is everything less like winnings. If somebody wins a big jackpot, that money goes out. That is not included in what's taxable. So the state takes 35% of that net, and it amounts to about $150 million. This is the largest revenue source from the pari-mutuels by a big amount, and is pretty straightforward from the division's end in calculating it. The formula to get a slot license is a little bit different than a card room, just in that there's an additional element. So the applicant would still need to have a permit. They still need to have an underlying operational license. I'm going to skip eligible facility for a second. They need to have the same completed application, and there's a minimum performance requirement for slots. So this is a full schedule. Full schedule is a defined term, and so slots are coupled to the pari-mutuel operations. The last requirement is the eligible facility requirement. Eligible facility is a term defined by statute. The site is there, and there's essentially 3 categories. As long as somebody fits into one of these 3 categories and is located in Miami-Dade or Broward County, they may be eligible for a slot license. This idea of an eligible facility has led to some litigation. Going back, South Florida Racing was the 8th slot facility that initially was not considered when the amendment passed. And then more recently, Gretna, Gadsden County tried to authorize slot machines, and this eligible facility was the significant litigated point. Finally, there's been some litigation recently on this connected contiguous issue. So essentially the statute requires that the slot gaming is connected and contiguous to the live pari-mutuel facility. But those terms aren't the clearest, and there's been some litigation recently about what that actually means. So let's move on to the next slide, but if we can we skip this one and we may come back to it and go to so this map is another map that was provided. This contains, it just shows the Indian properties in the state. The red are all Seminole properties. There's the Big Cypress one is currently not operating, but it shows, their rough locations. And then the green circle is the Miccosukee. The Miccosukee are still operating in the state. They just don't have a compact with the state, so they are sort of off on their own. And then the next slide is the final map. So this map shows, and again, this is the same year as the earlier map that showed all the pari-mutuel operators as they were operating. This shows non-operating permits. So again, if somebody says how many permits are there, my response is going to include these, even though these people do not have an operating license. So these permits still exist. Some of them have never operated. Some have operated, 20, 30 years ago. Some have operated a year ago. So it's a mix depending on the permit, but just know that there is the possibility for permits to exist that do not operate. And then if you go back to that FAQ slide two prior, I can touch on this quickly, and then I'm done and would be happy to field any questions that you guys may have. I think Ray Treadwell may also have a little bit after this one. So this is just a quick overview of some of the common questions that we get. So wagering at pari-mutuel activities. People can wager on live races. You go to Gulfstream, you watch a horse race that's happening at Gulfstream. People can wager on races that are happening at other facilities. You can go to Gulfstream this past weekend and wager on the Kentucky Derby at Gulfstream, even though the Kentucky Derby is happening in Kentucky. You can wager on card rooms, and you can wager on slots. But those are the authorized wagering forms that exist in the state. Permits can be issued, moving on to the second one, through county referendum, or essentially the summer highlight permit section. So the county referendum comes with it a geographic limitation. Most permits outside of summer highlight permits are limited by geography and how close they can be to other permits. So we're currently in a situation where it's very difficult to find an area in the state where a permit could be issued. There are supposedly some, I don't know what they are. The main route to getting a new permit is in 550.0745 via a summer highlight permit. Summer highlight permits do not come with the same geographic limitation. So in counties where these are available, people have applied, and there have been several summer highlight permits issued in the last decade. 3, can permits move? Yes. So the current 550 authorizes for the move of a permit or the relocation of Greyhound permits. So just understand that the law does not have to change to authorize some permits to move so long as the permit holders meet the conditions. We've seen some movement since Greyhound ended, where the Greyhound facilities are moving to locations that they believe will be more profitable. They are able to get rid, to essentially decrease the size of the property that's necessary to maintain their business by not needing a racetrack. So we've had two Greyhound permits move in the last 2 years. 4, what is needed to get a card room or slot license? So we've already kind of covered that, but just understand here the point is that they're coupled to generally live performances. So if decoupling is on the table, decoupling is the concept of removing the live performance requirement while still authorizing the permit holder to conduct other types of gaming. What's the status of Greyhound racing? So via constitutional amendment, Greyhound racing is now prohibited in the state. As of January of this past year, a Greyhound racing permit holder can't accept wagers on the event. But the permit still exists, and the language in the amendment allows them to conduct the other gaming businesses, and it specifically says that the failure to conduct Greyhound racing doesn't affect their ability to get these other things. So Greyhound racing and Greyhound race permit holders, are still in business. They're still operating. They're mostly operating card rooms, or like we showed Magic City is a Greyhound permit holder. They're operating slots because they're Miami-Dade and qualified as an eligible facility. Why are there more licenses than facilities? So, and this kind of goes back to that, the key point about the difference between permits and licenses. Often, permit holders operate their business at the same facility because if they can work out an agreement where they don't have to construct a fronton or Greyhound track, it benefits them. So we're in a situation where there's some examples where there are multiple licenses, multiple permits operating at the same facility. So if you're using the term facility, or if you're thinking in terms of facility, just understand that if you come to the division and say, hey, how many facilities are there? We're going to give you a number that doesn't represent the number of permits or the number of actual licenses there are. 7, what can the Seminoles do that the pari-mutuels cannot? So I'm just going to touch on this. I know that, I believe that Mr. Treadwell is planning on discussing this a little bit more in detail for some of the history of the compact, but for the 2010 compact, the Seminoles were granted the exclusive right for slots outside of Miami-Dade and Broward, so they were the only ones that could do that, and banked games. I think Ray will probably be able to speak more about the issues involved there. So, I mean, at this point, I don't have anything else in this presentation. For purposes just trying to wrap things up and move on. If anybody has any questions, I'd be happy to help.
If anyone has any questions, use the hand up feature or give a wave to the screen. Let's see. All right, Representative Cheney.
Hi, thank you. So with so many permit holders being basically inactive, is there anything they can do with those permits? Can they transfer them to somebody, sell them to somebody? I mean, do they have any value that they can give to others?
Well, thank you for the question. So, yes, the bottom line is yes. So they can be sold. There is some inherent value depending on who you ask. You know, some people, the seller is going to present, hey, you can do all these things with this permit. The buyer is obviously interested in buying the permit because they believe there is some value. But the way, you know, current law does authorize movement of permits under some conditions. It's not as simple as just, you know, asking the division, hey, can we move? But there is the potential for to you know, operate again or to move. But again, it's very fact specific, and it will really depend on the permit holder and what they're trying to do.
Do you have another question, Representative Cheney?
No, thank you.
All right, next we have Representative Williams. I sent the request to unmute. It should pop up on your screen, Representative Williams.
Good afternoon. Is it possible for him to provide his contact information? I have a couple questions, but I don't want to hold everybody else up. I can ask him off, you know, on my own personal time or with him.
Yes, thank you. I'm going to give you our Ledge Affairs here over at DBPR, and they work great with me. They'll get in touch with me, and we'd be happy to help answer any of the questions or set up a meeting. You know, we'd be happy to do that. What is the number? I can.
Colton. Keep telling the call our main line, 850.
So it's 850.
487.
487.
4827.
4827.
And then also my email address.
And as for Colton Madill, Madill. And his email address is Colton, Colton, period, Madill, Madill, at myfloridalicense.com.
Thank you
Yeah,
very
Florida
much.
spelled out. Thank you.
Thank you.
All right, next we've got Representative Woodson.
Thank you. Thank you very much, Mr. Trombetta, for the presentation. We appreciate the information as we're trying to be ready for next week. I have two questions. The first one, you mentioned that permits do not expire. You mentioned that earlier. Is there a renewal process for those permits that do not expire? And if so, how often?
Well, thank you, Representative. No, so permits, essentially, they kind of exist in perpetuity. There is no renewal period. They exist until something happens that would cause the permit to, have to be, like, the division could take action to get a permit back if somebody does something wrong. Or for, whatever reason, somebody could turn a permit back into the state. But they do not expire, they do not go void, there's no renewal. Once the permit is issued, the permit exists.
Thank you for that
Yes, ma'am.
information. But are they monitored since they do not get renewed? Or do we only wait until something happens? Is there a monitoring process in place for them to see if everything is being done as per code?
So if they're not operating, they're, we monitor in that we require ownership information. But if they're not operating, there usually isn't a bill, like for a lot of those permits on that map that we're not operating, some of them, there isn't a building on the property anymore. So think of it as almost like a legal, for purposes of law, a permit exists in this one place, but there may not be a building there, or it may be a whole different building on top of that property, and the permit may just still be there. So there isn't for a lot of these, there isn't necessarily anything to inspect when they're not operating. But for any of the permits that may, for whatever reason, still have, be open to the public for any type of reason that my division would regulate, we would continue to do inspections for some of the, for example, for Jefferson County Kennel Club. My team did go over and do inspections just as Greyhound racing was ending, just to see what was going on.
Okay, thank you so much. The last question is, you mentioned that one of your functions is to regulate license for the pari-mutuel. Do you regulate the license and you monitor the compact as well? Or you mentioned that you are the state compliance officer. Is that correct?
Yes, ma'am. So I'm going to separate questions into two parts. So we regulate licensed pari-mutuel operations, and this presentation really just focused on the permits and the operating licenses.
Okay.
But we also, we issue almost, I think there's over 20,000 occupational licenses. So if anybody that works in or around these facilities is required to have an occupational license from us. We provide all that licensing work too. As far as your question related to the compact, under the 2010 compact, the division was identified as the unit that was responsible for monitoring the compact. So there's a small team of employees that work for the division that continue to conduct the duties that were required under the compact. Now, our duties are not very in-depth. We have audit hours. We're allowed to audit and inspect the properties, and we look at financial data. So we get, but that's sort of our role as a state compliance agency.
So not monitoring the compact person, that's what you're saying, right?
No, ma'am. We do monitor the compact. We monitor, but what I'm trying to say is that our authority is limited by the compact.
Okay.
In other words, yeah, the compact spells out exactly what we can and can't do, and we try to stick just to that.
All right, thank you so much, sir. I appreciate it.
Yes, ma'am.
All right, next question is from Representative Bartleman.
Hi, yes, thank you. So I have a question. If you're in charge of the compact and we had an issue because the tribe didn't think that you were enforcing the compact correctly, then I guess there was a gray area and the courts ruled in favor of the tribe. Then they were paying. What is the rub now that they're refusing to pay us? What are you not monitoring that they have an issue with, or what are you not able to do so we could collect those dollars?
Well, thank you for the question. I know I spoke with Mr. Treadwell prior to my presentation, and it sounded like he was going to address your specific question. So if you don't mind, I'd like to throw it off to him. I don't know if it's right now or whenever he goes, but I believe he's going to address that exact subject matter.
Okay, so whoever's going to answer it, I just like to understand that. But you were the ones that were regulating them when the lawsuit came about, correct?
Yes, since the compact went into effect in 2010, the Division of Pari-mutuel Wagering has been the state monitoring agency.
Now
The
you
compact.
said your hands are tied as to what you can do. Were your
Yeah, but
Were your
yes, ma'am.
hands tied to regulating the enforcement of that? Because we're about to enter into another compact, and I think it's important for us to understand because we have gaming going on without collecting any money now because of the inability to regulate. So can you give specifics as to what you mean by your hands are tied and why you can regulate what was in the compact?
Yes, ma'am. So the context of when I said that was talking about cardrooms, our rulemaking authority in cardrooms. So the division attempted to create rules to address and draw lines on what is and what isn't poker. And DOA told us that we did not have the rulemaking authority to do so. Later on, and again, I know I'm kind of getting into what I think Mr. Treadwell was going to talk about. We attempted again to do something rulemaking-wise, and again, was told by DOA and ultimately DCA that we couldn't do that. So it's really a rulemaking authority is what I was referring to.
Okay, and then I look forward to the question in the next presentation. Thank you.
Yep, thank you.
All right, we have another question where you're from, Representative Thompson.
Thank you very much. I have a question regarding some gaming that's occurring in North Florida, Gretna, to be specific. How does that fit into the licenses and the permits that you addressed? And I believe they're out with the Creek rather than either the Seminoles or the Miccosukee. Can you address that for me, please?
Yes, ma'am, I believe so. So Gadsden County has a pari-mutuel facility at Gretna. Gretna runs quarter horse racing, so they have a permit to conduct quarter horse racing. Quarter horse racing is a type of horse racing. It's a smaller horse that is more like a rodeo horse than a thoroughbred. So Gretna, with that permit, they apply for and get an operating license to hold performances and to allow people to wager on the quarter horse racing. They run enough races, they complete a full schedule, or what I'm sorry for using the term full schedule. They complete enough performances that they're also entitled to have a card room. So their card room at Gretna is coupled with the fact that they're a quarter horse permit and that they have to run quarter horse races. So Gretna is a facility like lots in the state that have a pari-mutuel wagering operation and a card room. They do not have slots because they're outside of Miami-Dade and Broward. As far as the question about the Porch Creek Indian Tribe, so Porch Creek Indian Tribe is another tribal entity, mostly located along the northern part of the state, that has shown an interest in getting involved in gaming in the state. They do not have a compact with the state of Florida, and as far as I know, they don't have, I'm not familiar enough about whether or not they have tribal property in the state or not, but they are, as far as I know, an Indian tribe that's been interested in gaming, but may have some small ownership percentages of some of the pari-mutuels along the I-10 corridor. But so far, they do not have a standalone facility. They do not have a compact with the state. Did that address the question, ma'am?
It does, but it prompts another question. Revenue that's generated for the state, is that primarily from taxing in Gaston County, since there is no compact?
Okay, so I can get back to you with exact numbers. I just don't know how much was made at Gretna most recently. But the way the revenue works there is it'd be the same as other places. So there'd be taxes, daily license fees. So for all these, and sorry, it's a little bit more detailed, but if people when they run races, they owe the state daily license fees based on the number of performances on top of normal tax revenue. So there's revenue sources from the actual running of the races, and then there's also revenue source from the card room, as I've already described. They'll make money for the state through gross receipts tax and table fees on cards.
Thank you very much.
Yes, ma'am.
This is Kurt in Commerce. Just to reemphasize what Mr. Trombetta just said, that the facility in Gretna is an officially licensed pari-mutuel facility. It is not a tribal gaming operation. So it's officially licensed, permitted and licensed for the activities that he mentioned.
Thank you.
All right, does anyone else have questions for Mr. Trombetta?
Lara, I believe Ray Treadwell, the governor's office, is there anything you wanted to add before we wrap this segment up?
Yes, if I could just speak very briefly and provide a very high-level review of the current legal landscape that caused the tribe to stop paying in 2019, and that was kind of ever present in our minds in the recent negotiations. I am the governor's chief deputy general counsel, and I was directly involved in those recent negotiations with the tribe. And prior to joining EOG, I was general counsel of DBPR, so I have deeply studied these relevant gaming issues alongside Director Trombetta since early 2019. And very briefly, like the director said, the 2010 compact gave the tribe exclusivity over banked card games like blackjack. But then beginning in 2015, the tribe began complaining that the new designated player games at pari-mutuels were banked card games in breach of their exclusivity. That issue was litigated in federal court, and in 2016, there was a decision by federal judge Robert Hinkle, who agreed with the tribe that the designated player games are banked games. The very concept of the games, he ruled, make them different from poker and more like blackjack. Rather than appeal that ruling, DBPR agreed in 2017 to start aggressive enforcement against designated player games to keep the tribe paying. That also gave the legislature time to consider whether to eliminate the designated player games. As the director referenced, DBPR also tried to eliminate the games by repealing the rule authorizing designated player games. But then in 2017, the First District Court of Appeal stopped the rule repeal and declared the games a permissible form of poker, at least in concept. So that is where the legal impasse is. You've got one federal court that has ruled that the games violate some form of the tribe's exclusivity, but a state appellate court has protected the games as at least conceptually lawful as a form of poker. So since 2017, there really has been no easy solution out of this impasse that all parties can reasonably accept. Then, of course, Amendment 3 passed in 2018, dealing with player-banked games like designated player games, and that amendment, of course, ties the legislature's hands further. So by 2019, after 2 consecutive sessions with no solution from the legislature over the impasse and claims of no aggressive enforcement from DBPR, the tribe finally made good on its promise, on its threat to stop making payments. So in short, the situation since 2019 has presented limited options. Satisfying the tribe's demands would have crippled many Florida pari-mutuels, but the status quo of designated player games at many Florida pari-mutuels was costing the state hundreds of millions of dollars in lost tribal revenue. Now, we'll go more in depth on the terms of the new compact on Thursday, but for now, it is important to see that years of deliberation and legal actions has not yielded a workable solution to the legal impasse. What this new compact represents is a very hard-fought compromise and a creative path forward for all interested parties. The state avoids a long, protracted legal battle with the tribe over the 2010 compact impasse that could ultimately bring the state right back to where it is today with no money and no easy solution. Yet somehow this year, in the interest of progress, the tribe has accepted the status quo at pari-mutuels, agreed to partner with pari-mutuels on sports betting, and agreed to share more revenue with the state than it shared under the 2010 compact. So as you think through the merits of this new compact, please keep in mind that the existing landscape without this new compact is legally shaky terrain. And with that high-level overview, I'll be happy to take any questions.
All right, looks like Representative Woodson has a question.
Thank you very much, Mr. Treadwell, but my question was for Director Trombetta, actually. I appreciate the presentation. I appreciate the fact that you have shared all this information with us in order for us to really know about the old compact and the new compact as well. My question to you, you don't have to answer it now, but you can provide us with the information. By you being the overseer of the old compact and knowing that we have lost so much money between 2019 and 2021, and I'm not blaming you or anybody else, but I'm saying you know best what took us there to that road. So do you have any recommendation on what we need to look for in the new compact in order for us not to be where we are now? I know the state has some good attorneys. I'm not doubting that at all. But us who are going to look at the compact and work on it, I would like to see what would be your recommendation since you were in charge of monitoring, compliance monitoring the old compact. So that's my question to you. And you don't have to answer it now. You can always send it to us because I know it's a loaded one, but I would appreciate it if you can do that in order for us to really know what we should be looking for. So thank you.
Okay, and thank you for the question. I think I will take the option of trying to get back to you on that one.
Yes.
I would appreciate it. Thank you so much.
All right, does anyone else have a question? Use the hands up feature or turn your screen on and give a wave to the screen. Okay, I don't see any more questions.
Okay, I think I'm going to go on to the next. This is Kurt Hammond in the House Commerce Committee, and thank you to DBPR and the Governor's Office for answering those questions. I did just see another question pop up.
It looks like, yep, Representative Schlossberg. One moment.
Thank you. My question is, going back to these designated player games, so what is the status currently? Because I've noticed some of these designated player games popping up at some of these pari-mutuels more recently. So what is the status of the designated player games currently?
I can answer that. So they are being played. You know, if you walk into a pari-mutuel facility and go into a card room, you will be able to find designated player games depending on the facility. The majority of the card rooms are offering them.
Okay, I think if there's no further on, we'll go over to.
Okay, so is that issue still, is this still an issue with these, whether or not these designated player games are considered poker tables, or is there still issues with the Seminole tribe and?
Yes. All right.
Yeah. Go ahead, Ray.
Yeah, I'll go ahead and answer that. It's still an open question. I mean, there has not been a direct case definitively settling that legal question, and that direct case could be, you know, a breach of compact action between the state and the tribe. And I think that was the, you know, protracted litigation I was referring to that we are avoiding by setting a new agreement in place with the tribe. And I can tell you the tribe's main concern is they don't want to see the designated player games here in Florida morph into what they have become out in California, which is just a form of blackjack under a different name. And so with the hard restrictions in place that we've proposed here in the new compact, that satisfies the tribe's long-term concerns while also protecting these Florida businesses who have been running these games now for years and feel like they have sufficient protection under state case law.
Okay, thank you.
Okay, thanks again. We went a little bit long on that segment, so I'll jump right in, and hopefully everyone will stay on for at least most of the rest of the presentation. Like Lou said at the beginning of his presentation, we're going to go through some of the issues of other gaming that are not regulated by DBPR, including amusement games, bingo, charitable raffles, penny ante games, sweepstakes, and internet cafes. First up are amusement games. These are legal under statute in Florida, and they must be operated for entertainment purposes, and the player must control the outcome by application of skill or material element of chance, and contain no material element of chance. The games must be activated by coins, cards, coupons, slugs, tokens, or other similar devices. And they cannot have cash awards or alcohol or tobacco awards. There are penalties for violating this, and there are three main types of these amusement games. Type A is most understood by just showing the example, which is pinball games. And so these are typically what you think of as an amusement center where there's video games and pinball games where nothing of value is awarded other than replays of the game. The law does require 15 maximum replays per game. And it does also prohibit the use of knockoff switches, which I find is interesting. So I guess Florida law does not allow the pinball wizard to be cut off if he or she is continuing to play on their pinball games. These games, type A games, can be possessed by anyone and played at any location in the state. Type B are games that are similar to what would be at Fun Station or Dave & Buster's, where they're arcade-style games, but they award coupons or points for redeeming on-site prizes. Coupon value cannot be more than $5.25 as adjusted by the CPI, and no individual prize can have a wholesale cost of more than $525. These games, type B, may involve head-to-head competition. They have to be limited to certain facilities, including timeshares, public food and lodging establishment, and DBPR licensed arcade amusement centers, bowling centers, or truck stops. Type C are claw games that everyone is probably familiar with from your childhood, and these games may give the prize directly to the player. Prize value cannot be more than $52.50 as adjusted by CPI again, and they're limited in their locations also. The next area is bingo, and this is bingo being played at charitable locations. So I want to emphasize that this is different than the bingo games at pari-mutuel facilities, which is an option that is provided actually in both compacts, the 2010 and in the newest compact. And there have been discussions about authorizing those. They were not authorized by the legislature after the 2010 compact, but that again is different. This is bingo related to charitable organizations. These must be run by charitable nonprofits or veterans organizations, and they may conduct the bingo games, as long as the entire proceeds derived from the conduct of the games, less the actual business expenses, are donated to the charity. Other organizations can conduct bingo games conditioned upon the return of all proceeds playing in the form of prizes. So that's just if it's straight up no money is taken out of the game, it is just for prizes. Under this statute, no bingo jackpots can exceed $250. And instant bingo tickets may not cost more than $1. A little bit more about charitable organizations. In addition to bingo, charitable organizations may conduct drawings of chance and raffles and award prizes. The charitable organization must inform participants of a number of things, including that no contribution is required. This is something that confuses a lot of people at charitable organizations. The charitable organization may not condition the award of the prize on whether the participant has donated. So me being the legislative nerd, when different organizations that I'm involved in say they want to do raffles, I ask them if they're going to allow free raffle tickets to people, and they usually look at me like I'm somewhat crazy, but that is required. Penny ante games. These are games conducted in a dwelling or in a common area of a clubhouse, a condominium clubhouse. These are strictly limited to certain types of games and limited in which the winners of any player of a single round, hand, or game may not exceed $10. And there must not be any consideration or commission received for hosting the games. And also, admission may not be charged for these penny ante games, nor can advertising. The next option that is authorized by statute is sweepstakes games, and these are popularized by the McDonald's Monopoly game that a lot of people have seen at various McDonald's stores over the years. And this is a promotion in connection with the incidental sale of a consumer product. And these are where the player either receives game pieces or purchasing food items or sends in for free game pieces. Again, like the charitable raffles, these games must include no consideration clause, i.e. no purchase necessary. So you have to be able to request and receive free gameplay tickets. And if the prizes in your sweepstake are more than $5,000, the game operator must register with the Department of Agriculture and Consumer Services. Getting into some of the other things that DBPR mentioned that they get calls about, in the early 2010s, internet cafes and so-called adult arcades began to become commonplace throughout Florida. So in 2013, legislation was brought to reduce the criminal activity and the proliferation of these unregulated games. The legislation clarified and imposed new restrictions and prohibitions on slot machines and casino-style games, and applied these bans to the internet cafes and adult arcades. And restrictions on internet arcades were further clarified by additional legislation in 2015. Such internet cafes and adult arcades typically sold a product to the consumer, usually internet time or long distance calling minutes, and the consumer received sweepstakes entries that were determined to win or lose. With those entries, the consumers won cash prizes either directly or playing a casino style game. According to the cafes and arcades, they were operating sweepstakes, but it was generally considered illegal or illegal slot machine activity, as they awarded cash prizes for playing games of chance. More recently, some unlawful internet cafes and adult arcades have offered players a chance to play pre-reveal games, which reveal the outcome before a coin or token is inserted into the game. Such games have been determined by the First District Court of Appeal to be illegal slot machines. In order to curb internet cafes and adult arcades, many local governments have banned simulated gaming devices, which are the type of game that are typically found in unlawful cafes and arcades. Another thing that happened in the area of gaming in Florida, cruises to nowhere. In the early 1980s, cruises to nowhere began, and the industry grew in the 90s to have many ships operating out of a lot of ports in Florida. For reasons including increased cost of operation and expansion of legal gaming in Florida, the industry began to decline in roughly 2008. Currently, the industry is limited to a few ships, generally operating out of limited ports. Going on to the next part, which this is looking at the current gaming landscape of sports betting and fantasy sports. Both of these items are authorized in certain ways under the new compact, which again, like was mentioned earlier, we will go into the details of the new compact on Thursday. But let us just go through some of the current situation of sports betting and fantasy sports in the state and also in the nation. This is a very difficult subject with lots of over the past 100 years, there's been lots of historical enforcement of bookmaking, illegal sports betting through bookmaking, and Florida has laws prohibiting that. But in recent years, there's been very limited enforcement related to online sports betting and also related to fantasy sports. So the key thing to learn is to try to understand the difference between sports betting and fantasy sports. There is often a fine line between these two types of programs. And now some of the original fantasy sports operators are now doing full-on sports betting, so that makes it even more confusing. One of the key differences is who do the participants compete against? In sports betting, they compete against the house, and in fantasy sports, they generally compete against other participants. The participants on sports betting wager on the outcomes of real sporting events, while fantasy sports manage fictitious sports teams composed of athletes chosen from a professional sports organization, and the winning outcomes are predominantly determined by a statistical performance of all the athletes put together. Is this a skill or chance? In sports betting, many believe that sports betting and fantasy sports involve some level of skill, where winning outcomes in sports betting are generally determined by more so to be chance than skill. Under fantasy sports, theoretically, winning outcomes in fantasy sports involve more skill in comparison to the skill needed for a winning outcome in the sports betting on the actual real performance. Is it gambling? Sports betting. Sports betting is classified as Class 3 gaming under the Indian Gaming Regulatory Act regulations. As far as fantasy sports goes, there have been no specific legal determinations on specific programs or proposals in Florida. However, to the extent that fantasy sports involve skill, then perhaps no. While fantasy sports can be played over the course of an entire season, daily fantasy sports are a variant of fantasy sports that are played over short periods, often ranging from 1 day to 1 week. Daily fantasy sports has been criticized for being more of a game of chance than skill, and thus more akin to the traditional gaming sports betting than to traditional fantasy sports. This has become a bigger issue, the question of sports betting, within the last 2 years. In May 2018, the U.S. Supreme Court invalidated the federal law which prohibited most states from operating sports betting. Since the ruling invalidating this federal law, other states have authorized or implemented sports betting. Florida's legal situation regarding sports betting appears to be more complicated than most states because 6 months after the court's ruling on the federal law, Florida voters ratified Amendment 3. The amendment seeks to ensure, according to the text of the amendment seeks to ensure that Florida voters, rather than the legislature, have the exclusive right to decide whether to authorize casino gambling in Florida. However, the amendment does not include pari-mutuel wagering on horse racing, dog racing, highlight exhibitions in the definition of casino gambling. The amendment does not limit the legislature's authority to restrict, regulate, or tax any gaming or gambling activities. The amendment does not limit the ability of the state or Native American tribes to negotiate gaming compacts pursuant to IGRA or the conduct of casino gambling on tribal lands. And finally, the amendment does not affect any existing gambling on tribal lands pursuant to compacts executed by the state and tribes pursuant to IGRA. As I mentioned, the sports betting in the country is a relatively new phenomenon, and a number of states have moved, and I'll get into more details from some NCSL data in a moment. But this shows some general states with their sports betting revenue and also their taxes generated since the beginning of these programs. A few definitions to keep in mind when we're talking about sports betting is handle, which is the amount wagered over the time period. Also revenue, which is the amount of money kept by the sports books out of the amount wagered. And then the hold percentage is how much revenue sportsbooks keep as a function of handle. And then taxes and state revenue, taxes collected by the state and local jurisdictions, or the state share of proceeds in revenue sharing markets. Let me go through a little of data that we found from the National Council of State Legislatures. So again, these are relatively new authorizations. And so the number of states that are participating in this has continued to grow. As a matter of fact, I think there is another one that's about to pass or has passed that would change these numbers a little bit. But sports betting is offered in 20 states plus the District of Columbia. And it is legal but not yet operational in another 5 states. A handful of states, including North Carolina, New Mexico, and Washington, do not have state-approved sports betting, but have authorized it at certain tribal casinos. Intrastate mobile sports betting has been authorized in 14 states, DC, and Puerto Rico, so bettors can place their bets from their phone or computer. Interestingly, in Tennessee, sports betting is only available online. Of these states, 3 states allow it very narrowly. Mississippi, Montana, and Washington only allow bets from a mobile phone to be placed while on casino premises. The tax rates on sports betting at these other states vary widely. Most states have tax rates between 5 and 20%. In Pennsylvania, the state gets more than 1/3 of all revenues of sports betting, and a few of the states with lottery run operations take half of the profit or more. In general, the tax rates for retail and mobile operators are the same. However, New Jersey uniquely charges a higher tax rate for mobile betting, with 9.75% for land-based betting, and then 14.25% for online betting. According to NCSL, again, this is NCSL and their data and their review, higher rates may maximize state revenues. However, some states have produced lower rates to make legal sports betting more competitively priced with illegal market products, and thus encourage more gamblers to leave the illegal market. Based on the revenue numbers in the state so far, there is still no clear relationship between the tax rates and the revenue performance of those states. Other states have also imposed licensing fees related to sports betting. Evidence that NCSL reviewed suggests that mobile gaming creates larger revenue streams, but there are also potential costs to weigh. Opponents have expressed concern that making gambling opportunities available online could lead to higher rates of gambling addiction and destructive personal finance decisions. Sports betting continued from NCSL data. In general, sports betting is a relatively low margin compared to other gaming opportunities. Most wagers received are paid out for player prizes. Nationwide, the average hold for a sports book is 7.2%. So even in New Jersey, sports betting brings in roughly 20 times less revenue than the New Jersey lottery, and is only a fraction of the total casino gambling in New Jersey. New Jersey currently has the largest sports betting market. In calendar year 2020, it brought in $49.4 million in new tax revenue for the state. Mobile betting accounts for 95% of the total amount wagered in the state. Pennsylvania brought in a total of 38.7% in state revenue. Roughly 3/4 of that was from mobile sports betting. Now we'll get into some discussion of illegal sports betting. I want to stress, and I'll stress it again later when we get into some other numbers, that these are all estimates. And since the illegal sports betting market is inherently difficult to measure, all of these estimates need to be taken with a grain of salt. Such illegal sports gaming occurs in a variety of formats, including betting with bookies, online betting with offshore operators, and through casual forms of office pools. In 1990, the National Gambling Impact Study Commission estimated the size of illegal sports betting handle in the U.S. was between $80 and $380 billion per year, and revenue was $4.8 billion to $22.8 billion per year. In a more recent study conducted by Ernst & Young for the American Gaming Association, they estimated at least $149 billion is bet illegally in the United States. Using this estimate, the illegal sports betting market would rank 15th on the most recent Fortune 500 businesses based on revenue. In 2015, Ernst & Young did an online consumer survey and found that approximately 28% of all U.S. adults bet on sports, wagering an average of over $1,500 over the previous month. As applied to the currently available demographics for Florida, these figures equate to approximately $7.5 billion in estimated annual sports betting in Florida. Again, all of these are based on estimates of illegal activity, which is inherently difficult to track. Continuing on, related to illegal sports betting, even after legalization, the legal sports betting industry may face competition from illegal sports betting due to the competitive advantage that these illegal operators have by not paying taxes. And they would therefore be able to offer more attractive odds and lines of betting than legal operators. Additionally, illegal operators may benefit from prohibitions imposed by states related to certain types of sports betting. Although not all bettors will immediately shift from illegal to legal sports betting, legalizing sports betting may cause individuals who do not currently wager on sports to begin betting and may cause those who are currently betting illegally to wager more money than through legal operators. The AGA survey on sports betting consumer behavior in 2019 shows that bettors are increasingly choosing legal sportsbook over illegal operations when placing their wagers. In states where sports betting was not yet legal in 2019, bettors reported a 21% increase in the use of illegal sports betting methods. However, in states with legal betting, bettors reported a 22% increase in the use of illegal sports betting methods. The top reasons cited by most studies why bettors shift to legal sports betting include confidence that the bets will be paid out, awareness of the legal options, and a desire to use a regulated sports book. Professor and criminologist from Virginia Commonwealth University conducted a study that demonstrated the strong ties between illegal sports betting and organized crime. His study found that illegal gaming operators are typically large-scale, involving between 8 and 33 people, often operating online and offshore for many years. Illegal gaming operations financed a range of criminal activities, including money laundering, racketeering, drug trafficking, extortion, and human trafficking. Just quickly go through a few other estimates related to illegal sports betting and the public perspective. Again, these are from other entities, and so please use caution in reading too much into these. The AGA commissioned a survey prior to the Super Bowl in 2015, and it found that 72% of Super Bowl viewers believe allowing states to regulate sports betting will make it safer. 65% of the viewers believe that transparent regulated wagering will either strengthen the integrity of the game or have no impact. And 68% believe that regulated sports betting will generate funds for much needed local programs. In a 2020 survey by AGA, they demonstrated consumer confusion about the legality of some of the methods related to sports betting, and thus the need to further educate consumers on how and why to bet legally. 55% of the illegal bettors in this survey believe that they were mostly betting legally, even though they weren't. 84% of these bettors were surprised to learn that they are betting on illegal websites. Fantasy sports market. The number of fantasy sports participants in Florida may be between 3 million and 3.3 million. Again, this is using outside source data and extrapolating it to Florida census data. And this is based on the Florida Sports and Gaming Association, where they found that 19% of all Americans age 18 plus participated in fantasy sports. So that's how we get the upper level estimate for the number of participants based on the census of Florida. Another estimate had it at a slightly different value, and that's where we get the range of the 3 million Floridians possibly participating. Fantasy sports law generally, the Federal Unlawful Internet Gambling Enforcement Act of 2006. This is federal legislation that prohibits any person engaged in business of betting or wagering from knowingly accepting various forms of payment in connection with another person's participation in unlawful internet gambling. The definition of bet or wager expressly excludes fantasy sports that meet certain criteria, but this does not have the effect of fully legalizing fantasy sports. Skill versus chance in relation to fantasy sports. states have taken different approaches on whether fantasy sports are gambling. In most states, fantasy sports are not considered gambling if they involve more skill than chance, which is called the predominant factor test. In a minority of states, fantasy sports are considered gambling if results are based on any amount of chance, which is the any chance test, or if a chance is a material element that affects the game's outcome. This is the material element test. Again, these are other state tests regarding to fantasy sports legality. While fantasy sports can be played over the course of an entire season, DFS, like I mentioned earlier, is another variant, and these variants have been criticized for being more of a game of chance than skill, and thus more akin to gambling and sports betting than to traditional fantasy sports. An important thing to note is that Florida law does not expressly address fantasy sports. As such, there are currently no licensing or regulatory framework for fantasy sports. The legality of fantasy sports appears to turn on whether the contest involves a stake, bet, or wager versus a purse, prize, or premium, and on the determination of skill versus chance. There are two important Florida statutes related to this. 84925 is Florida's anti-bookmaking statute, and it deals with similar games and has specific standards that may apply. The other statute is 84914, which provides a criminal penalty for persons who stakes, bets, or wagers any money on anything of value upon the result of any trial or contest of skill, speed, or power, or endurance. The statute also punishes any person who receives such money or thing of value and any person who aids the prescribed acts. In 1991, the Florida Attorney General's office issued an opinion related to specific and certain fantasy sports activities and determined that those were unlawful. And finally, although 849.14 and 849.25 criminalize stakes, bets, or wagers on trials or contests of skill, there's an important distinction in the case law between stakes, bets, wagers, which are illegal, and a purse, prize, or premium, legal if it involves skill. A stake, bet, or wager is something of value put up by parties with the understanding that one or the other gets it for nothing but by chance. A purse, prize, or premium is something of value offered for the winner of a contest, but for which the one offering it does not compete and stands no chance to recover any part of it, and for which the entry fee does not contribute to the prize or pool. If the purse, prize, or premium involves a feat of mental or physical skill, it is not gambling. If the purse, prize, or premium is contested for a game of chance, it is gambling. A violation of state law related to these statutes may also be a violation of Federal Illegal Gambling Business Act, depending on the size of the illegal business operation. And that completes our presentation. I'm sorry we've gone over our time, but we definitely are available for questions.
All right, if anyone has any questions, use the hands up feature, wave to the camera. All right, I do not see any questions. Oh, Representative Woodson has a question. Give me a minute.
Well, since no one has a question, I have some other questions. I don't want to take, to monopolize the time, but since no one has any questions, I have two questions, so I'll go ahead and answer them because I'm trying to be familiar with the topic. The first question is, I asked this question this morning, but I did not have a response, and I know Attorney Treadwell is on the call, so I want to know, can he provide us with some explanation on it? And I would ask the second question to Mr. Tromboda. The first question has to do with again, the funding from the first compact, since we can see that it's a lot of money from 2019 to 2021. Is there anything in the contract that can go back to get retroactive payment from the tribe, even if it's a percentage of the $350 million that was supposed to be paid to the state, even if it's a percentage? Is there anything in there, any loophole that we can go back to in order to get some retroactive payment?
Sure, I'll do my best to answer that question. There's nothing explicit in the new compact, but it is factored into the guaranteed minimum payments that the tribe will be making us in the first 5 years. The
I'm
hurdle
sorry,
we
I was
have,
referring to the old one. I'm sorry, I was referring to the old, well, the existing one, not the new one coming up.
okay, so in terms of the retroactive payments since 2019, we could not put a provision in the new compact demanding retroactive payments and yet still get it approved by the U.S. Department of Interior. That would be a major flag, and I don't believe the Federal Indian Gaming Regulatory Act would allow us to do that. So what instead we've done is we have proactively demanded that the tribe make these minimum guaranteed payments in the first 5 years of an average of $500 million annually. And nobody expects the tribe to reach that $500 million on their own gaming in those first 5 years. So there will be a ramp up for the tribe that, you know, they'll be paying us more than we would be entitled to under the rates themselves. But in order to get us into this deal, we have demanded this minimum amount for the first 5 years. So however you want to calculate it, I do believe that a fair amount of what you might consider back payment for the last couple of years is factored into how we've structured it moving forward in the first 5 years of guaranteed minimum payments. Does that help?
That helps a little bit. I wish, how about between now and until the other one become in effect? It's nothing that you can do as well between now and
until
until the other one becomes into effect. Yeah.
Right. Until Interior approves the new compact, nothing short of bringing a, you know, litigation against the tribe and winning it would get money from them at this point.
Okay. All right. So thank you for answering this question. My second question has to do with illegal sports betting. As we can see with the presentation, it's a major problem and it's very high, and it's a lot of money that we could get, you know, in the state that is going into illegal sports betting. I want to know what is the state is doing about it to combat it, and what are we putting in place in order to make sure at least we put measures in place and in order to get some of that money, as we need it so much in the state.
Well, I'll try to take that one, Ray. Probably be your preference. I think this is Kurt again in the House Commerce Committee. There has not been major enforcement that I'm aware of the illegal online gaming in Florida, but the proposals that were proposed by both the House and Senate in regular session did have enhanced enforcement provisions with the creation of a new gaming control commission, which would have law enforcement powers and would enable them to go out and be more aggressive in their prosecution of illegal sports betting or any illegal fantasy sports that did not follow rules if we adopt rules related to fantasy sports.
Okay. Thank you for that response. That was going to be my recommendation, to have a gaming commission assigned in order to address the problem. So I'm glad to see that we're doing something. And what would the commission be composed of? Has that been determined or not? Like, who will be part of that commission to make sure that we have the right players in place in order to address the issue?
That is not determined. Again, I was mentioning the two bills in the House and Senate that had similar provisions during regular session. It is not guaranteed that those actual proposals will be the ones that we'll be looking at next week. That's still in development, from my understanding. So we don't know exactly what the status of those will be.
Thank you very much, sir. I appreciate it. Thanks.
All right, does anyone else have questions? All right, I don't see any questions. Thank you, everyone, for joining us today, logging in. And hopefully we'll see most of you tomorrow in what we're calling summer school here in the Florida House. All right, see you later. Bye.
Thank you.
Thank you.